Let's start now.
Oh,
Like I said, I wanted to talk today about new construction contracts and, the fact that we kind of have this, it's a two-part analysis. Number one is educating your client about new construction, kind of what to expect, how to evaluate certain issues, what's realistic and what's not. And then number two is what does the actual contract say? How can you legally protect your client, give them the right advice? Dad, you've done a lot of new construction reviews with people over the years. Is there anything that kind of jumps off the page when I say new construction contract?
you need to check whether or not you can list the property before you close, whether that's a violation of the contract. There's a number of developers who do that.
And that's interesting. And I think I wouldn't even have thought to go there, but it's a really interesting point. Why does your mind think that way? Why do you even worry about that?
Because I had somebody write a $40,000 check to Jack Antaranian over this. It's buried in the language that a listing of the property, and with some developers, Luckett back in the day would do that. There's a couple, I ran across one a few weeks ago who had the same thing. And I had to deal with an attorney on the other side, whether or not that would be considered putting it in MLS would be considered putting it in the public records. They usually have a provision in there that you cannot record the contract in the public records. And the agent at Downing Fry was looking to list the property before the buyer closed so they could turn around and market it and have a contract that would close after the first buyer closed with the developer.
Right. So in that scenario, the reason why that was relevant is that buyer wants to make this as an investment, not necessarily a home that they're going to live in or use seasonally. They're really thinking, all right, if I buy this on the ground floor, by the time it's done, I think it'll be worth more.
You go to new communities back when Quail Creek, for example, was being developed. They had provisions in their contract that if the raw land wasn't developed within 12 months, that developer had the right to purchase it back. They have a huge vested interest in making sure it's a living, breathing community with people who send their children to school, and it's not just something on paper that people are trying to flip.
Yeah, and that's something that's kind of been unique to the last, I don't know, 10 years or so, maybe, I guess before the 2008 recession as well, when the prices were going crazy overnight, so that it was a viable business. I remember when I was working for you, Dad, when I was in high school, and I actually worked with Celia Dyfick, and she had clients who were trying to back out of deals that they'd put a deposit on 2 properties, and now that they were coming due, they weren't worth as much because the economy had tanked. And so it is at times a viable business model to put deals under contract, put a $250,000 deposit down, hoping to just spin it and make $250,000 or more.
Now, Celia was part of a statewide group that was looking at violations of the Interstate Land Sales Act. That's why you see that language in the developer contracts that the closing will be no later than 2 years. That's one of the safe harbors.
Yeah, it's really interesting. So that's a great start to this, that you have to be careful as to who your buyer is, what they're going to want to use. You have to know your buyer, and that is part of that contextual decision making, that contextual, how do I need to read the contract if I think my buyer's just flipping this, that they want to relist it. That's a very different kind of buyer, different analysis than if you have someone that wants to just live in it or is using it seasonally.
Well, it's in the fine print, Christian. I mean, if you can't record the contract in the public records and you get a not hate letter, but you got a letter from another law firm, which we did a few weeks ago, that listing it before our client actually closed on it. They had it under contract, which is fine under the NABOR listing agreement. That gives them an equitable interest in the property. So with anybody else, if they were buying from you, they could list it. But this particular developer was taking the position that this was the public records and was a violation of the contract.
Yeah, and so why would a builder be worried about this? I'm looking at it from 2 reasons. A builder might restrict being able to sell it before you buy. One, they don't want to compete with you on new listings, and number 2, they want to get paid. So if there's a new estoppel letter, if there's, some of these associations have a 25, 50, $100,000 initiation fee, and they want you to pay that on both closings.
Right.
So they're going to try to avoid you being able to assign the contract. In fact, we'll look at a contract that has non-assignability language in it. And so they're kind of those two things that they're worried about. It's all about
I mean,
the
on
money.
a related topic, Nabor has an addendum, I believe, on back-to-back closings where you use the money from buyer number 2 to pay seller number 1, the
Right.
ultimate.
Yeah, and I think it's really interesting. It's kind of, you have to be transparent. You got to be pretty not sophisticated, but you got to be careful about how you negotiate those deals. But let me share my screen. So this is a contract that's used here locally. The first thing to know about new construction contracts is that they're all different. I would say most of the production builders, the Lennars, Toll Brothers, the GL Homes, they're going to use their own contract. You're not going to see a Nabor or a FAR or FAR-BAR contract. You're going to see a unique contract. So right off the bat, you have to be careful, because this is something that you may not know how to read. You may not have any experience going through this. And so the safest thing to do is say, what you really need to do is hire an attorney and go over this together, because I can only do so much. I think that's the safe move to go. And Dad, you and I talk about that a lot with many different things, but this is one thing that I think gets lost in the weeds a lot, because what we'll show you, in fact, this contract has where they specify who the title company is going to be.
Yes.
And so a lot of buyers are like, all right, well, I have to use this title company. I don't need to hire an attorney, or I don't want to spend the money. Well, the reality is Allegiant Title, in this case, they're not really working for you. They're getting the business because the builder is sending it to you, sending it to them. So, and they probably don't have an attorney on file or on staff. So it's a huge windfall for them if they can just blow you off. Well,
the developer always tries to get you to use their title company and their lender. They make money out of it. They know what exceptions are going to crop up because they got title insurance when they bought the land to start with.
Yeah.
So if they have a joint venture with whoever on the title insurance, and they also have an interest in the lender, they make a lot of money. That they might give the buyer a credit if they use both. They might flip it around. I've seen this where the buyer pays documentary stamp tax on the deed and the seller pays for title insurance. So sometimes they do that. You go back 20 years and the buyer would pay a developer fee of like 1 to 1.5%. And then the developer would provide title insurance to the buyer and pocket the difference. So, they ultimately try to keep control of the process. And you're right. People think that they have to use their title company. In many cases, they don't. Comes down to
and so let's talk to that point.
Mm-hmm.
Title insurance, who do you get to use? What they did in this case is they said that the mutually agreed upon closing agent shall be this title company. Closing shall be held at the builder's sales offices or the offices of the closing agents determined by Neil. This is something, I think the simple way of evaluating this is the builder paying for the title, and therefore I'll let them choose whoever they want, or am I getting some sort of large credit if I use their title company? And what I see more and more is that unless you're using their title company and their mortgage company, that credit doesn't exist. They're not paying for anything. So be careful. If the builder's not paying for your title insurance, then use someone that works for you, that's getting the business because you brought it to them. And the agent, I think, can drive a lot of that. So what I always tell an agent is, it's just one deal, but I work really hard for the agent because I know they're bringing me more than just that one deal. They're bringing me a half a dozen or a dozen deals a year. And that relationship is so important that I'll over deliver, overperform, just to keep everyone happy. And that's what the buyer wants. The buyer should get an attorney review. Dad, you and I are attorneys. We'd be happy to review things for clients. And it doesn't cost them anything if we're doing their closing. However, if we're not doing your closing, we do tend to charge a flat rate, something to just review file, go over the contract with the client. And I think it's value added. I think that it's something that every buyer should seriously consider.
Well, I mean, the sheer fact is most of these developer contracts are really long. I mean, they're monstrous.
This one's 56 pages, and I have a feeling it doesn't include all the attachments and the, addendums.
And there's all sorts of pro developer language in there, and there are pitfalls to look out for. And can you have an inspection company come in and do the walkthrough?
Yeah.
Which we strongly
let's go through some of that. So in this scenario, you've got an initial deposit, and then within about a week, they want the additional deposit. Just like a resale contract, you see those deposits. A lot of times we do see very high deposits, somewhere 10 to 20%, as opposed to maybe 5 to 10%. So you just want to make sure that you're not overextending, because Dad, you mentioned this earlier, 2 years is usually the time frame to be able to deliver a house from a builder's perspective. Imagine having your 20% deposit tied up for 2 years. Yeah, you want to make sure your buyer realizes that that's a possibility.
I mean, you got to remember that the developer has their own sales agents. They're in the sales business. The 2 years isn't necessarily when you're going to close. It's just something that's in there to comply with the Interstate Land Sales Act. People get freaked out over it,
Right.
But that it's a common issue.
Yep. All right. So So this particular builder had 2 scenarios, and I think this is a really good transition into the next, probably even the most important question that I will ask when I'm reviewing one of these contracts. How far along is the construction on this house? Because where you are in construction tends to determine how much risk a buyer has to whether this is going to be completed on time. So you've got home construction completed, and alternatively construction of home. So the second one is if construction of the home has not commenced or been completed as the effective date. And so imagine the scenario where the home is 95% complete. They're painting, installing, the screen and the landscaping. They're just waiting for that CO, the certificate of occupancy. You're not taking a 12-month risk. That 2-year completion date is almost irrelevant, because we're right there and I can see the finish line, and the builder can give us a legitimate ETA, as opposed to they haven't broken ground or they've only laid the foundation. I like to say that that's probably your riskiest scenario, because you're now going to live with that builder for the next 9 to 12 months or 6 to 12 months. And you're going to see the ups and downs of supply chain management and labor shortages. And it's almost, Dad, one of the reasons that I like this business is that most of my relationships with clients is at 30 days at a time. I can't mess too much up in 30 days. We have a defined term, but if it takes me 12 months to close your house, you're probably going to get frustrated with me at some point. You're not going to like that very much. And that's what working with builders can be like. Yikes. All right. So that's kind of the big one there. We talk about the issuance of certificate of occupancy. The next thing to know is that's usually our goal line. Some buyers think or assume that the goal line is a 100% complete house, but actual contract usually is something different. It usually requires just a certificate of occupancy. That's when the county or the city has determined that the house is safe to live in. Check the box, permits are closed, we're good to go. Usually what you're leading out behind is maybe landscaping hasn't been installed. There's still painting required. Maybe there's a fence or some doors that need to be installed. It's like 98% complete. Were you saying that?
Yeah, and they have partial COs sometimes that they close on as well.
Yeah, a builder can sometimes negotiate partial COs, and that would be, let's say a lot of times counties will require landscaping installed, but if the builder's asking and they put a bond up or they do something different, some counties will do the partial COs to say, all right, we don't have the landscaping, but we still want it. Change orders, everything's going to have to be in writing. Selections, I don't get too much into this.
It has to be done timely, otherwise they charge you.
Yeah, and that's what you'll see here in this particular contract. But for me, when I'm reviewing a contract, that's usually the one thing that that the sales agent, the on-site sales agent, does a decent job of explaining to a buyer, because that's the buyer's job, and they're excited, they put it on their calendar. So I don't usually bring this up as a big item, just because the buyers are already on top of that. It's the other stuff that the sales agent doesn't go over that I worry about. So this one, the builder shall provide at least 10-day notice of closing date. So that's where it's very different from a resale contract, is that you could have no communication, poor communication, and then all of a sudden, hey, closing is in 10 days. I've seen 7 days as kind of the minimum, but that's where the builder's saying, hey, we got our CO, we want to set closing for 10 days from now. And so what I want to make sure of is that the buyer realizes that's how quickly this will turn. Within those 10 days, they're going to schedule your walkthrough. They're going to need the rest of your money. So you're going to have to make sure you're liquid enough to make that happen within 10 days. You have to sign the closing. You're going to want to maybe take possession. And this is a very common thing. Otherwise, they will charge you for every day that it is delayed. They may also declare the buyer to be in default. They usually don't do that unless the value is much higher than what they're selling it at. But the key is buyer really needs to be ready. Buyer needs to be ready.
How about delays for walkthrough, Christian? Are you going to get into that?
Yeah, we'll get into that. Let's do that now.
Okay.
Actually, it might be a little later in the contract here.
That comes up all the time. That's why I asked.
Yeah, so let's go through the contract. I think it'll come up later. The thing that I thought was interesting here, I highlighted, the builder shall deliver to buyer a boundary survey. It's usually a lot cheaper for a builder to provide this than it is for a buyer to go out and get their own, because they have a survey company that help them, survey the entire property, the entire community. So I always like to see that this is in here. Now, the interesting thing about this property is that they actually make the buyer pay for it. If you notice here on section 9.3, the buyer's paying for the cost of a survey. I would probably want to know what that cost will be. Is it $150 or is it $850? I thought that was an interesting thing that I haven't seen very often, because they make the seller deliver or provide it, but then they make the buyer pay for it. The next thing, they've got buyer paying for cost of owner's title insurance. See, I'll highlight that. Title search fee, cost of survey, a $250 fee to Neil for contract administration. Neil is the builder. Customary closing fees to the closing agent. Recording costs for recording the deed, it's usually $20. Doc stamp tax to be paid, I highlighted this, with the recording of the deed. Now, Dad, you mentioned this earlier. Typically, this is a seller cost here in Southwest Florida.
And the NABOR and the FAR contract, yeah. Yeah,
NABOR and FAR, they're going to make this a seller cost. So I would say this is, again, normal. And you'll hear me use that word a lot, normal, because I want my client to know, am I getting screwed here, or is this just part of the deal? Is this just cost of doing business for new construction? I would say this is cost of doing business for new construction, but it adds up. So if you're buying $1 million house in Florida, doc stamps is going to be $7 times 1,000, so $7,000. It can be a big number if you're not used to or expecting that cost as a buyer. Estoppel fees, that's pretty normal. And then they have an additional builder fee of $1,500 due at closing. I see this all the time as well. The builder is just kind of putting one more fee. In this case, they actually put 2 fees because they had that $250 charge as well. I hate this fee. I think it's just as frustrating as the doc stamps tax, in my opinion, but it's normal. Every builder does it.
You remember the purchase price, Christian?
What'd you say?
Do you remember the purchase price on this?
This one's $500,000.
Okay, because as I mentioned earlier, the bigger deals, they used to just charge the buyer 1.5%, and then the developer supplied all this stuff. And it was more than enough to cover it and make a profit.
Yeah, this is just a different way of doing it, I guess. They could just say, hey, we'll give you we'll pay for it, and then we're going to charge you a fee. I think they were probably having trouble with that because of mortgages. And one thing that'll come up on this particular contract is that the buyer is getting a mortgage.
The federal statute.
So as an attorney, this next section is really important. So when we review contracts, we want to look at what are the buyer's obligations, what are the seller's obligations, and then what happens if they don't do those obligations? What happens then? So this is always something that we need to look at. If buyer defaults under this agreement, all earnest money deposits and all other sums paid by buyer to builder shall be retained by builder as liquidated damages for such default in lieu of all other damages. I think that's what you guys are used to, is that you would lose your deposit. Right. And then the interesting part, Dad, I know you'll love this one, or builder may sue for specific performance. That's pretty unusual, wouldn't you say?
Yeah, although FARBAR has equitable remedies in there, this is what this is. Specific performance is an equitable remedy, which in English means it's up to the judge. They have discretion looking at the facts and circumstances.
Yeah, so specific performance is that the builder can force you to close on this house. And to me, what I've always understood is that a judge would look at this and say, was it mutually agreed upon? You know, is this something you negotiated for? I don't know if this is something that the buyer can negotiate for when they just throw it in there. You've got a 56, it's a little.
I don't think I've ever seen a seller get away with equitable remedies in this situation.
I've only seen case law where it was negotiated by two sophisticated parties. So if it was like you're selling a retail complex, and it's $100 million sale, and you've got attorneys on all sides, and they put this in there, and it was discussed and negotiated, I could see a judge following through on that. But usually we don't force a buyer to close. It's only the buyer that can force a seller to close. Yeah. Now, to that point, if Neil defaults under this agreement prior to closing, all earnest money deposits shall be paid to buyer. In addition, Neil shall pay to buyer interest on the deposit at the highest rate then payable by commercial banks in the county which the property is located on regular passbook savings account as liquidated damage such default in lieu of all their damage, or buyer may have such legal and equitable remedies that may be allowed in Florida law, including specific performance. So this is, I don't know, it's interesting. It's a lot. Usually what we see is liquidated, you get your deposit back, or you can sue for specific performance if you can't do both. This one really kind of goes on and on. Provided, however, consequential, exemplary, punitive, and special damage shall not be permitted. So basically they're saying, hey, you get your deposits back plus interest, or you can sue us for specific performance. I'd say that's, for the most part, that's normal, but I haven't seen the interest rate thing. I thought that was interesting.
Well, that's because of the mutual consideration rule, that JRL versus Hackett case. There has to be consideration on both sides, and getting your own deposit back under JRL versus Hackett is not consideration. You're getting your own money back. Right. And a side point on specific performance, I've seen a lot of situations where the buyer gets it because the property is unique. So it's when the judge is looking at it and he's trying to decide what to do, or she's trying to decide what to do. This is just the one and only property like this in the universe. Versus the seller, you could have 4,000 different buyers for the same property. So they're not.
They just want the money.
The buyer isn't unique to the seller.
Right. So what I like about this for a buyer, I would say this is one normal. It's what I would have expected. But what I like about this for a buyer is that if the market goes crazy and this property appreciates before they even close, the builder can't just cut them out of the deal. Say, here's your money back plus interest, and I'm going to sell it to someone else for more. This would give the buyer real leverage to enforce the sale of the contract at the original price. So this is what I would expect. If there was anything less than that, I would be unhappy with it. And that kind of goes to someone's question online here. It says, make good points. Have you been able to get a builder to revise the contract to be more palatable, or is it more about the buyer understanding what they are getting into? It's a great question. And I think you saw right through it. A lot of this is just an education, because most of the time, even if a builder might be willing to negotiate on some of these points, usually the sales agent says they're not. You can't even get past the gatekeeper. More important to me is I want my buyer to be really educated about what the pros and cons. I want to empower them as to making a right decision for themselves and say, well, I'm okay if we get delayed 2 years because I have this house, this is just an investment. Or because I'm not getting a mortgage, it doesn't matter if the interest rates go crazy. But if you had a buyer who is getting a mortgage, is very interest rate biased, or the interest rate really matters for the affordability for this particular buyer, these things might talk a buyer out of it. The buyer may say, hey, look, I can't afford to do new construction because I don't know where the rates will be 9 months from now. And I don't want to risk my 50 grand that would be in deposit. If 9 months from now, the rates are double what they were now, the buyer wouldn't be able to close. And so for those people, I would worry about that. And that's why I want to educate the buyer so they can make decisions. And then hopefully, to your point, maybe there's one thing that we go back to the builder on and we say, hey, we really have a problem with the interest rate risk. What if we put a certain language? Here it is. If interest rates go beyond 9%, buyer may terminate, and here's how the deposit will get released. That might be a good solution for that particular buyer, because I never want to talk them out of doing it. I just want to make sure that they're educated about it. Does that make sense, Dad?
Yeah, I've had a little luck with some modifications. They will never change the form. I mean, that thing's like the Bible.
The standard, yeah.
Yeah, but if it's a slower market, you might be able to get 1 or 2 points on an addendum. And they're very touchy about credits because they don't want other buyers to think, oh, the market's going down and they shouldn't pay so much.
Yeah. Next section here is on warranties. I really haven't seen much deviation between different builders, but it's usually a 1-year warranty on workmanship and
That's
a 10-year
true.
warranty on foundational things. This might be a little different than that, but you would expect to know exactly what your warranties are at the beginning. It shouldn't be a surprise to you later on. Oh gosh, this isn't warranted. One thing we never see warranted is landscaping.
Yeah, if I could, this is where an inspection company comes in real handy. One, you get the punch list items, which are different than the warranties beforehand. And 2, you get things that might not manifest themselves until past the 1 year. You might not have things hooked up properly, which happens frequently, but it might not show up until 1.5 years after closing. So if you get an inspector in there doing the walkthrough for you, you'll pick that up.
Yeah. This one's important too. Neil expressly disclaims any and all warranties, including any common law implied warranties of fitness for a particular purpose, merchantability, habitability pertaining to such off-lot buildings and site improvements. The reason why I wanted to point this out, and this section as well about oral representations, is that this seems to be a pretty common occurrence where the on-site sales agent for the builder will just say things because that's what they've been told, that's what they've seen. But there is a difference between what's happened previously and what could happen on your deal. I almost wish you and I weren't trained this way, but the reality is you and I are trained to look for worst case scenario. We look past who the person is that we're talking to, and we say, all right, they can say whatever they want, but here's what you get. This is the minimum that they have to give you. So we'll get oral representations, for example, on closing date. Oh, I've never seen it, or oral representations regarding, hey, if we don't close by January, just let us know and we'll let you get your deposit back. And it's really nice when you hear those things, but if it's not in the contract, you don't get it, right? If the builder's struggling financially, they may not let you have your deposit back. Maybe the guy who made that decision last time, maybe he's no longer with the company. And I think that is something that we find a lot of buyers get themselves in hot water over, because they take it at face value what the person told them on site. And 9 months later, it's not like that anymore. It's tough. That being said, to this builder's credit, someone told me just now, I've worked with Neil and they were great with our buyers who had to sell something first. So that's really encouraging, that there are builders that follow through. I just want to make sure that you put it in writing. If it needs to be an addendum, or we just look specifically to one section, if we can negotiate on one thing that matters most for our buyer, I think we can make this very much more palatable in the other person's wording. So here's that language data on assignment. This agreement is personal to buyer and may not be assigned. If Neil assigns its rights to another person or entity that assumes, Neil shall be relieved of further liability to the buyer. So if you're going to sign the contract, if you're going to own it, if you want to put it into a trust, you can't do it unilaterally the way you might be able to in a NABOR or FAR-BAR contract. We would want to look at this specifically, but really this is going back to the previous point. This is to protect the builder from you being able to make money without them. They don't like that very much. They don't want you to compete with them. Importantly, they always have a section about brokers. So this is a very relevant section to have, and for you guys to review for your own businesses. I want you to make sure that you are reviewing this. Buyer warrants this agreement was not procured by any real estate broker, and the cooperating broker, if any, whose name appears in the broker addendum attached here too. So this is a very important section that your name is listed, or the brokerage name is listed as a party to the contract. And in this scenario, they have a broker addendum. That is a pretty common thing. That is what I would expect to see most times. They've got disclosures. Homeowner association, Dad, you and I talked about this yesterday or last week on condos.
Last week, yeah.
That there is a section here specifically for new construction. This is a language right from the statute. If the disclosure summary required by section 720 has not been provided to prospective buyer before executing this agreement is voidable by buyer by delivering to Neil or their agent written notice of the buyer's intent to cancel within 3 days. So this is the HOA disclosure law. Have you seen that happen on a new construction deal before?
Well, they supply it later or be off a little bit. Yes.
Yeah. The key is, and we have this frequently, you want to know if your intended purpose with this property is going to be allowed by the development, even after you buy it. So I'll give you an example. I was representing a client who was going to Airbnb the property, short-term rentals. And there was nothing in the covenants that prohibited it, but we were at least a year away from being able to take possession. And so I told the buyer, I said, look, if your purpose is specifically to rent the property short-term, you want to make sure that you are protected in this contract. And so we actually came up with language and proposed it to the builder. They did accept it, which was nice. And it said, seller warrants that this property shall be permitted to do short-term rentals. So, and up until closing, basically. Now, after closing, could the HOA change their declarants or their bylaws and rules and kind of prohibit it? Yeah, it's possible. But I wanted to make sure that if they changed it prior to closing, that the buyer had a right to get out of the deal, because that was what was important to them. So that was the one thing that we went back on that deal. Property tax disclosures, more disclosures are great. Flood zone determinations, this is the standard stuff. And again, unless it's stuff that your buyer is particularly concerned about, some of the stuff you can just roll right through the way we're doing here. But Dad, this was the part that you wanted to go over on that.
Yeah, this is the one that comes up a lot. A common issue, especially if they're coming from up north, if they have their walkthrough, they find something they don't like, they try to delay closing. I mean, all the time they want to delay closing, and that's what they're used to up in New York and different states. Every developer contract I've ever seen doesn't allow the buyer to delay closing. You can do a punch list. They have a reasonable period of time to comply with the punch list. And that's that. You don't get the delay. What I recommend to the buyers is check out the developer. If it's Lennar, if it's Toll Brothers, if it's somebody that you and I have dealt with for many years, back before WCI went bankrupt and was taken over by Lennar, I could say with some authority that we've never had a problem with them, but check out whether or not the people that have used them before have ever had cost overruns. Do they show up on the punch list items on a timely basis? Any surprises? How are they to work with? Because these contracts are heavily in favor of the developer. Get their hands dirty like we do with the condos.
What's interesting about this particular section also is it gives you a roadmap as to what the builder usually messes up. So let's look at this. Buyer has made a personal on-site inspection of the property, including the lot, subdivision, and other areas surrounding the subdivision in which the lot is located prior to buyer's execution, is familiar with the lot and surroundings, accepts the lot and the surroundings and their existing conditions subject to such changes. There are no view easements associated with the property, and the view of the surrounding subdivision features may change. So that's one thing that builders really kind of do a poor job of, is educating a buyer that, hey, look, you're only house 8 in 100 lot subdivision. It's going to change drastically. We haven't installed everything yet. Buyer has reviewed the community documents and reviewing all the restrictive covenants, rules and regulations, and accepts the configuration boundaries of the lot are as depicted on the subdivision plat. Dad, you and I have a family member that bought a property from D.R. Horton and didn't realize that there was a big access easement on the side of their property that was going to require a gate and all this. And so they buy the house. They were one of the first in the subdivision. And then like 6 months later, the builder comes and installs this gate with a gravel road in their front yard. They were beside themselves, but it was on the plat. It was listed right there. It's just that no one pointed it out to them. So
they didn't
do
the closing.
Yeah, we didn't do the closing. It was in Georgia. Buyer has not relied on any physical markers, viewing stands, or other conditions to determine the configuration, elevation, or boundaries of the lot. You know, you don't know what you have until it's built and the whole thing is done. The lot may differ in size and configuration. They're conforming with local building codes. May remove trees at its sole discretion. Buyers not received or relied upon assurances related to preservation, conservation, or open space area. Again, we want to look at the plat. We want to make sure we know exactly what's getting installed, what's being preserved. The answers are out there. We just have to actually do the research and look for them, as opposed
Some
to
of
just
this is Johnson B. Davis stuff. They're telling you, that there might be a shopping center down the street, essentially, if you look at the development plan.
Yep. Termination. This agreement is contingent on, and builder may end this agreement at any time of the following occur. That the builder determines that for reasons beyond their control, Neil cannot achieve substantial completion within a reasonable time after estimated date of substantial completion, unable to obtain necessary public or private approvals, or determines in sole absolute discretion that there are irreconcilable difference between Neil and the buyer. That's a nasty one there, Dad. You like that? Yeah, that's a fun one. So interestingly, you look at the default language and it says, oh, well, if the seller's in default, then you can sue me for specific performance. Well, unless the builder has determined in their sole and absolute discretion that there are irreconcilable disputes between the builder and the buyer.
In other words, they get out if they feel
They can
like
get
it.
out if they want to. It's their sole discretion. Irreconcilable. You won't pay me more money. Could you imagine? So
checking
for
out
context,
the is so important, because you just don't know.
This is a pretty nasty little section here. For context, I worked with a builder in Atlanta who said that had language similar to this. And I brought it up to their attention and said, hey, I don't like this. This is kind of nasty. And they said, we would never use it. We would never use it. We never have used it. It's, boilerplate language. We don't change the contracts, right? That's what the sales agents are told to say. Well, they used it. COVID hit, prices doubled, and they canceled an entire subdivision worth of contracts. But they'd never done it before because they could double their prices, their profit. They could triple their profit if they did that. And it's exactly what they did. So the never, woulda, coulda, shoulda, all that, this is important for a buyer to know. If this is something that we need removed. Now, why would a builder put this in here? Well, buyers can be a pain in the neck. They want to come to the property every single day. They want to ask for updates. They want this and they want that. And why hasn't it been completed? And we've been delayed 6 months. It can be really problematic. So someone asked a question. I had an issue with a builder last week where I requested multiple times and talked to the closing agent before closing to see the closing statement. They never did send one in advance. Is this normal? Okay, so you're only as good as you need their business. That's the sad truth. Dad, you and I, we want people to have a great experience with us because we want you to come back. But when you work with a builder, you're probably not coming back, and when the title company got the business from the builder, they don't really care to make you happy. They might try a little bit if they're great, but really they care about keeping the builder happy. And so if you understand that, you can understand why they're just ignoring you. Where, yes, you should have a closing statement a couple of days in advance at the very least, just so you can go over it over coffee. But if the title company doesn't really want your business, if they don't, if they didn't get it because they're great anyways, they're probably going to blow you off. It's a sad reality. We see it a lot. I mean, we see it, Dad, with lenders, with out-of-state lenders. If they got your business because you're a Bank of America client, well, they're not as invested as if you are tied to the real estate agent. If you're one of the local brokers that we love and they want that repeat business, you just get a different response time.
You get a response.
You get a response, which is helpful. Going back to the certificate of occupancy, we have another question. I sold a custom home and the builder did not have a CO at the time they agreed the buyer could move on. Can a buyer move into the new home without a CO? Not legally. The county or the city could stop you. They could do a cease and desist. They could evict you. They could condemn the property. They could lock it up and board it. They could fine you and penalize you. Likely they wouldn't do that. If it's a custom home, let's say it's a couple $1 million home, maybe the city would work with you, but you can't really move in. You could close, you really shouldn't move in. I really haven't seen a buyer do that. I have seen where they agree to close, even though the CO hasn't been issued, and we work out some financial arrangement to accommodate the buyer, but I have never seen it where the buyer actually moved in.
Huge legal liability on this if the property isn't safe or wasn't built correctly.
Yeah, I would say that
huge.
I would not recommend that. I don't even know how to protect a buyer who wants to move in. I would say that's a problem. Let's look at the rest of this, see if there's anything else. These special tax districts, that you see on the NABOR and FAR you might have a form that talks about the disclosure of those. They put it right into their contract. Some of these bigger communities, you're going to have additional tax liabilities in that scenario. So now you've got your addendums, and this is, you've got your association addendums or subdivision. They're trying to clarify it. So in this case, the debt assessments are about $1,800 a year, and then maintenance is $400 a year. Just as a quick summary on how this works, if you're buying in a subdivision that has one of these, you really need to know two questions. Have they paid off the debt, which is like a county bond? Have they paid this off for the installation of roads and utilities? And if so, or if not, how much is it? How much is left? And then if they have paid it off, well, what is the annual maintenance going forward? So I would say in Collier County, most of the properties, the debt has been paid off, but you still have that maintenance assessment, which is ongoing. So think of it as a little higher tax bill.
Well, it might end up a part of the tax bill down the line.
Usually it is, yeah. More disclosures. This is where they have the affiliations. So who are they affiliated with? Do they have an ownership stake? And so this is the part. This part is the tricky part. If you have a buyer getting a loan, there are a couple of things to consider. Is that normally, and I apologize if I'm giving too much information on this particular closing. So normally, if you're getting a conventional loan, the builder will give you a financing contingency period. Let's say it's 21 days or 35 days, somewhere in that range. Well, you've got to make sure that you get everything approved as much as possible within those 30 days, let's say. But then it ends. Well, if your closing isn't for 6 months, your 30-day contingency doesn't really do much to protect you. It doesn't.
You're not locking in the rate.
Yeah, you're not locking in the rate. You're not locking in the appraisal. So you have an appraisal risk because the appraisal really can't happen until closer to a CO. So you're still taking a pretty large risk, even if they give you a financing contingency. So just be careful. A lot of buyers think, all right, I got your financing contingency, we're good. Check the amount of days. So if it's 6 months expected closing date, and you need a 6-month financing contingency or 5.5 months maybe. In this case, it was different because it's a VA loan. And on a VA loan, there really is no limit on the amount of days. If a buyer gets denied for a VA loan and it has a VA contingency in here, the buyer can get out no matter what the date was. If it doesn't appraise, buyer can get out and get all their deposit back, even if the contract says otherwise. So in this particular case, my buyer is more protected because it's a VA loan, but if it was a conventional loan, I would probably go over this a little bit more detailed with a more fine-tooth comb and just try to understand what kind of risk is the buyer willing to take in this case. That makes sense, Dad?
Yeah, and I usually recommend they have backup money. I mean, VA loans are a little unusual.
Yeah, VA loans are unusual. I think it's wonderful. But the interesting thing on this one is that the builder is actually pretty hesitant. They're pretty swift as well. They realize it's a VA loan and they don't want to kind of get caught on that. So what they are saying is that, hey, we're not going to put in a pool because that could throw the appraisal, right, and it could delay us further. And then you could get out of the deal because it didn't appraise. Whereas if we keep the pool in, they had a lot more control over what that appraisal amount should come into, and they felt much more comfortable about it.
I guess my point was, and couple this with something you mentioned earlier, if the developer only has to give, say, 10 or 15 days notice of closing and you're getting a mortgage, it might be a push for the lender to get everything together. So you need to have backup money. Yeah,
that's great. Finally, this is a good one, special stipulations. So this is where we might put in everything else. If buyer closes the purchase pursuant to the terms of the agreement, and through the seller approved closing agent, or buyer elects to pay cash directly and closes through builder's approved closing agent, $1,500 builder fee as defined in the agreement shall not apply. So they're basically, that's where the money's coming from. We talked about that earlier. That's where the buyer's getting a credit if they use their title company. Whereas, all right, well, what's the cost of using their title company versus using my own? You know, if you're hiring, Ross Title or Ross Law to do just a buyer review and to kind of be your attorney on this, is it still worth using the builder's title company? Or should I just have Ross Title do it and not pay the review fee?
Here's another way, Christian, if I might. I asked the buyer how long they intend to live there. And if they intend to live there, if it's a retirement home, if it's somebody who's my age and they're going to live there for the rest of their lives, you can pretty much do the math and figure out how long would it take to get back that $1,500 when you compare the rate you're getting from the builder's lender to the rate you get from some local lender. There's usually like an 1/8 of a point or a 1/4 point difference. And how long does it take to get that $1,500 back? And which one is economically better?
Yeah, I can almost guarantee you that at $1,500, you should probably just use your own company, use someone that you trust and get a lawyer to review it. For us, we don't charge attorney's fees. When it gets a little more challenging is when they're offering you $12,000. And then I will tell you, hey, take the 12 grand and pay me $1,500 to just review everything for you. Then you get both the best of both worlds. So, we'll be pretty honest with you. You gotta, I'm not going to ignore a $12,000 credit. $1,500, a lot simpler to do that on $1,500. So I think that's kind of the meat and potatoes that I wanted to go over. There's a lot there. The key in my mind is educate your buyer. Don't force them, but empower them to make the right decisions when talking to the right people. Look to the fine print as to what your costs are and determine what is normal versus what is abnormal. Because if it's normal, we can get you comfortable with it and say, hey, look, I hate the fee too. I don't want you paying it, but if you want new construction, that's the cost of doing business. As a different analogy, I had a buyer buying a golf course, and there was a golf course buffer easement that basically cut into the buyer's backyard by like 30 feet. And he's freaking out. Oh my gosh, 30 feet. They could make me remove all my landscaping and remove my porch and patio set. And I said, yeah, but if you want to be on a golf course, every lot is going to be subject to that same thing. And their focus is in protecting the visual impact. So as long as you keep as long as you kind of talk to them and understand, like, is your property in good shape or is it in bad shape? They're never going to pull that card. But if you want to be on a golf course, it's the cost of doing business. It is what it is. So I hope that was informative. I think we're seeing a lot of new interest in builder contracts. I think the builders are coming back to the table with incentives. You even saw in this deal, the builder was giving a $25,000 incentive to the buyer. And, given that financing contingency and a bunch of other things that they weren't doing 18 months ago. So we might see a big push for new construction. Insurance is lower. You get all the amenities, it's brand new, but there's always risk, and you want to make sure your buyer understands it so that when it happens, it's not the first time they heard about it. So anything else you can think of, Dad?
No, I think you covered it, Chris. Good job.
Love it. All right. Thank you, guys. Good luck this week, and I hope you had a wonderful 4th yesterday. If you need us, feel free to reach out, and you can find us online at rosstitle.com. Thank you.